right, the last speaker that we have for today is Senator Davis.
Okay, before Senator Davis come, is there anyone that we accidentally omitted that signed up to speak and we did not take their testimony? Okay, hearing none, here's the man of the hour, Senator Davis.
Thank you, Mr. Chairman, for inviting me, and thank you to Mary Dennis and the extraordinary job that she did in preparing and going over these materials. And I got to say, I've been extremely impressed by the questions that you've asked, either before or against the bill. I think a lot of information was brought out in a very short amount of time. I'm just going to touch on a few key things, and then I'll be happy to answer any questions or make myself available at some other time. Representative Brawley was all over this whole 1980 red herring. The 1980 Act is about clinical trials. It is about data. It is not about access. That question came up in the Senate. And if you were going to utilize that 1980 bill and the clinical trial approach to provide access, give you an idea, these are the numbers using what Dr. Nakakati and Dr. Cutler. Dr. Nakakati you heard from today. Dr. Cutler is the Dean of the College of Pharmacy here at USC. It'd be about $500 million to study 10,000 patients for 5 weeks, with half of them getting placebo. Okay, so you can ask yourself whether or not we have the political will to put several $billions on the line every year to get a clinical trial, and that's assuming you run the gauntlet of the DEA and the FDA and all the approvals you need to get from the feds to do clinical trials. So I just say that to say that the 1980 law isn't an answer at all. It's about access, as Representative Hart was saying as well. The second thing I would say is listen to the people who have testified before you here today. Those that have been in favor of this bill have been predominantly physicians, who say they want this alternative, pharmacists who say they want this alternative in a way to help patients, and in fact, they endorse this bill now, and patients, and the most compelling was from Gary Hess, who said he was on the verge of committing suicide until he had access to this. So you've got doctors, patients, pharmacists begging you to get out of the medicine business. The legislature isn't prescribing medicine. The legislature isn't getting involved in medicine. The legislature is getting out of it. It's saying that those decisions are best made by the doctor and the patient in consultation with each other. And so that's the first point I'd like to make. The second point I'd like to make is that the statement was made that the federal government, the federal agencies, they haven't acceded to this. We have a supremacy clause issue. We got a problem. You've got every year Congress passes a budget proviso that says to the Department of Justice, you can't use any of this money we're appropriating to you to challenge any state that has a medical cannabis law. It is against the law. You can't do it. You've got the IRS publishing regs on how cannabis businesses should file their taxes. You've got the Department of Justice laying out terms for mergers and acquisitions. You have the Department of Treasury giving guidance to banks on how to deposit medical cannabis funds. The federal government, it assumes this is a done deal. 37 states are doing this. The states are already acting. And Congress is acceding to that by saying we recognize that and we're instructing our agencies to be cognizant of that fact. The last thing I'll say is this, and I'll take questions because I only have 3 minutes. I keep hearing that if we authorize medical cannabis, there's going to be an increase in impaired driving. We have had the experience of 37 states with this, decades of experience, 6 independent studies, one conducted by the Department of Transportation saying there is a negative correlation between medical cannabis laws and incidents of impaired driving. Impaired driving goes down, unequivocally down. It's not even a question. And it's because cannabis and alcohol are substitute goods, okay? The tendency is if you take the one, you don't take more of the other. And you are more reckless, you are more dangerous, you are more of a threat to people if you're behind the wheel with alcohol than if you're somebody who has taken medical cannabis. That's a fact, and that's empirically shown. So when they make these statements without citing any authorities, I'll give you the 6 studies, including the federal one by the DOT, that shows there is a correlation between medical cannabis laws and a decrease in impaired driving. So I would just beg you, let's get out of the medicine business. We know it's got medical properties. In 2017, the National Academy of Sciences looked at 10,000 different abstracts, and said there was conclusive proof, the highest of 5 levels, that cannabis can be medically efficacious in regard to neurological disorders, chronic pain, a number of conditions. We know it's got medical benefits. Nobody seriously argues that anymore. Why not give doctors that discretion? Like with ivermectin, like with other things. If they're sitting down with that patient and look at this bill, it requires the physician to go through a whole checklist of things before that doctor can authorize cannabis use. Very, very thorough. This isn't Colorado, okay? You cite Colorado statistics. Colorado is the most lax laws in the country. They've got recreational use. There's a reason they don't cite statistics from medical cannabis states, because the data in those states don't support what they're trying to sell you, okay? There's a reason 37 other states have done this. Even more conservative states in South Carolina, believe it or not, have done this. And none of them have walked it back. In fact, the states that have adopted medical cannabis laws, they've expanded it over time to cover other conditions. Nobody has retreated back from medical cannabis laws because they're efficacious, because it relieves suffering. And you've heard the stories. And what if it were your daughter or your wife or your husband that was suffering from a medical condition and suffering an excruciating pain that nothing would give relief but some cannabis? I would get the cannabis for my wife or for my children, and I believe that you all would too. We ought not make them do that, though. We ought not make them break the law. If a doctor thinks it's in that patient's best interest, we ought to get out of the way. This is not the legislature prescribing medicine. This is legislature getting out of medicine. And to your point, Representative Hart, everybody knows why this was put on the Controlled Substances Act back in 1970. It was racial. It was President Nixon wanting to get out the war protesters. It was wanting to stick it to them. And we know that because we've seen the tapes. We've seen the transcripts. There is no medical reason to have done this. It is a purely political reason. And our idea about cannabis has grown up around that. It took me a while to realize there were medical benefits, because I was used to thinking of it in terms of recreational use. And I smoked it at Furman, and I got a 3.9 at Furman. So I can tell you right now that it isn't going to take you down the road to harder drugs and more and more and more, or I couldn't have got good grades. It doesn't do that. But even if you concede that, we're not talking about recreational use. This is a medical bill that is so tight. It's tighter in terms of the qualifying conditions. It's tighter in terms of what you have to demonstrate to a doctor in order to become authorized. It's tighter in regard to pharmacists being the ones that dispense it. It's tighter in regard to the quality control measures. It's tighter in regard to anything you can think of, because we have had the benefit of 8 years of working on this and looking at 37 states that have legalized this and seeing what's worked and seeing what hasn't worked. And I love and respect law enforcement and the sheriffs and the chiefs and Mark Heel and them all. And I sat down with them and put into this bill as much as they told me they could offer. If there's anything more they want to offer, I'll listen to that. We took out smoking. We put in a whole host of things at their request. And again, because I want this bill to be, and I've said this consistently, I've gotten to the point where people on the left, in terms of the spectrum, don't like this bill anymore because they think it's too darn restrictive, because it doesn't normalize. They want it to normalize, but this doesn't. This makes it clear that it is medicine. In every page of this bill, it treats it like medicine, from the labeling to the way it's advertised, to the way it's dispensed, to the way it's authorized, for the conditions for which it can be used. It is medicine. That comes through loud and clear, and I'm proud of that. Because I want people to look at South Carolina's law and say, if you want a law that helps patients, that empowers doctors, but doesn't go down the slippery slope to recreational, this is your bill. This is the bill you ought to take, your model legislation. Because that is what I think South Carolinians want. And why do I say that? Because poll after poll after poll, if you ask South Carolinians any number of different ways, they want to empower doctors, they want to benefit patients, they want to draw a bright red line against recreational use. That's what came out of the Senate. That's what's before you today, and I hope that's the bill we can send on to Governor McMaster. I'll be happy to answer any questions.
Okay, thank you. Any questions for the senator? Mr. Hart, Mr. Hart. Yes, sir.
Thank you, Senator Davis, for all your hard work over the years. This has been in our subcommittee for all those years, so I really appreciate it. One is more technical. under 4453-2230A, where it talks about possessing cannabis or cannabis products in any correctional facility. I've come to learn that DJJ is not always considered correctional facility. They may not consider it. Would you be open to adding DJJ to that? It's really more
Sure.
of the wording, but I have learned that sometimes DJJ is not treated as a correctional facility. So if you're open to adding DJJ, that it will be illegal.
Right, and I talked to Director Sterling, called me about that, and he caught me when I didn't have the bill in front of me, but I said I was confident that we did not authorize it in those correctional settings. If the language in the bill is too narrow, certainly the intent is as you say, Representative Hart.
Okay.
And in regard to, I mean, any number of things, I mean, Mary Dennis did a great job in looking at and pointing out a problem in regard to the pharmacy dispensing. So there's going to be other things that I would encourage you to look at and make this bill better. I mean, that's the way the legislative process works. I mean, somebody was saying to me, do you want your bill just to go through and get to the floor? And I said, no, I want the 3M committee and I want Chairman Howard's committee and the members of that committee to pick this bill apart and to figure out if we fell short, to figure out if things that we said, like you said with the DJJ, aren't correct, or the pharmacy piece of it. And so the most gratifying thing about this time around, this iteration, has been the coming together on the dispensing side. We were always good on the front end, very conservative, had to have a medical doctor, had to have an in-person examination, had to have a mandatory follow-up, you know, had to go through a checklist of have you tried other things, what's your substance abuse history, are there any indications that this might not be good for you? We were always very strong on that aspect of it, but not as strong on the dispensing side because, and this always bothered me because once the authorization is given, and you're right to point out, it's not prescribing, it is authorizing, and it's not prescribing, that the patient then goes down to a dispensary and there is an element of trial and error that occurs at that level because certain ratios of THC and CBD may interact with the body's endocannabinoidal system in a way that others might not. So it might take you a while to figure out what ratios are going to address your underlying condition. And it always made me a little bit uneasy that we didn't have a medical professional down at that level. And so one of the really good amendments that came out of the Senate process was bringing the Pharmacy Association into this, opening up, going to the South Carolina Board of Pharmacy and Pharmaceutical Board, and sitting down and saying, okay, if we want to have your medical professionals there, interacting with the patient, giving advice, following back up, how can we make that happen? And they helped us make that happen. I mean, it really was extraordinary. And we sat down and we hammered that out over a 2 or 3 week period. So we've got a process now that at the front end has doctors with very hands-on specific diagnosis in person. On the back end, we've got pharmacists interacting with patients. In between that, we have a security system in terms of the growing, the processing, and dispensing, where you know where the product is at all times. You've got independent lab testing to make sure of purity and making sure each product is labeled so that you know exactly what you're getting, so that you have that ability to make adjustments. And we just really, this is a piece of legislation that South Carolina can be proud of. I really think, to Representative Hill's point, this is the culmination of 8 years worth of work. And I really think we have a bill we can all be proud of.
Thank you, Senator. Ms. Brawley. Mr. Gilliard.
Thank you, Mr. Chairman, and thank you, Senator Davis, for the hard work that you've put into this bill and for the ability and the willingness to try to include as many people involved in this process as possible. I want to just make a comment about one of the people who testified this morning, and I think this goes to the essence of what we really ought to consider. I think the bill is a good bill, but we will meticulously go through it. But she said something that I think is very indicative of what happens very often in South Carolina. I think one of my colleagues asked her a question as to whether or not she had gone out of state to make certain that she was able to get the help that she needed for her child. And she said, no, I could not afford to do that. And I think we have an opportunity in this committee to look at that, because basically some people can afford to leave South Carolina to get the help that they need, but very often they cannot. And I think this bill allows us as a state to take care of our people.
Yeah. Yes, ma'am.
And that is what this bill, in my opinion, does. But we will, as you say, meticulously go through the language to make sure we have left nothing out. But thank you for bringing the matter forward.
Thank you, President Raleigh.
Mr. Gilliard and then Mr. Jones.
Yes, sir. Senator, I want to echo the sentiments of my peers up here. You got good spirit. Love the way you handle yourself all through this. And I would hope, and I'm just saying this, I would hope that you could carry that same spirit. And I know you're a proponent of my hate crime bill. And of course, you know, we named it after the late, great Senator Clemente Pinckney, that you would help that, see that through also. So thank you,
And
Senator.
there's a parallel to that in that that bill is too often mischaracterized because the opponents say that is creating a thought crime. It isn't doing that, okay? You have to commit a crime that's already on the books, and then judges, if there is a hate component to it, that can be a sentence enhancer. It's not creating a new crime. But I'm share your frustration when I see bills and I hear them mischaracterized and hitting on certain buzzwords. The challenge is to cut through that and to make the argument. And I think there's a lot of parallels there between that hate crimes bill and this Compassionate Care Act. A lot of the things, and quite frankly, some opinions in regard to the bill were formed 7 years ago when I was first starting out with this, that have changed materially since then. For instance, Mr. Bruder didn't realize that what the bill says now is if you are pulled over and suspected of impaired driving and you refuse a blood test for THC, you lose your license to the same degree if you didn't take a breathalyzer, okay? So the bill does provide for the taking of blood if you suspect a probable cause for impaired driving. So, I mean, that's an example of my frustration in that when I hear concerns that are voiced, I take steps and amend the bill, and then they go back and they voice the same concerns that have been addressed through the thing that's been changed. And so I would encourage the bill to be read with those eyes.
Okay. Mr. Jones. Okay, Mr. Jones.
Thank you, Mr. Chairman. And Senator Davis, I just want to commend you. Thank you for all the many years of work on this bill. When I look at this and think about the amount of work that's gone into this, I don't know of another piece of legislation that has been vetted and that we've had the deliberation on to this extent. So I just want to thank you for that. You know, probably about 10 years ago, a friend of mine, his little girl was diagnosed, had a brain tumor. And I saw firsthand them struggling, trying to find treatments in South Carolina, and they left South Carolina. And I can tell you, luckily today she's alive, she's doing great, but the point, people shouldn't have to leave our state in order to find those alternative treatments. So I want to thank you again.
Yes, sir. The other thing I would say is this, and don't like to look at things in Republican, Democrat terms. It's either good legislation or not good legislation. But I think it's instructive to note that in the Senate, 17-10, Republicans favored it, and 11 to 6, Democrats did. So it was roughly a 2-to-1 ratio on both sides. You had social conservatives from the upstate joining together with libertarian people on the coast. And I do think that speaks to this bill having been vetted, having been carefully drafted, and one that we can get behind and be proud of. And anyway, I really am gratified that you guys would take an entire day to hold this hearing, to let everybody who wanted to be heard, and the obvious degree to which you guys have been involved and the questions that you've asked. Ms. McGarry and Mr. Dabney, you as well, were on opposite sides of this issue, but your questions were right on topic. And one of the things I want to follow up with you with, ma'am, is in regard to the dosage. I think, and I made this mistake too, it speaks to milligrams, which is more in regard to weight, as opposed to milliliters, which would talk about the volume. But I can get you more materials on that and how that was arrived at, because those were good questions. Yes, ma'am.
Okay, I'm sorry. Oh, yes, go right ahead.
Thank you. Thank you. We're just curious as to why the bill limits to 15 licenses for the cultivation centers.
That was a concession we made early on at the concern of law enforcement. The concern was that this was something new, that this was something that we'd have to develop norms and protocols and standard of practice. And they were concerned about a situation like in Oklahoma where they simply have unlimited number of licenses and they wouldn't have an opportunity really to understand things. I liken it almost to like a pilot project where you're limiting the number of applicants, the number of people that they have to monitor so that we can study it and making sure there's no unintended consequences. And that was the reason behind it, was that this was something new. I guess the conservative in me is like, okay, go slow. Okay, take this first step. Let's make sure that we're not overtaxing the resources of DHEC and SLED to monitor this, because they do have extensive monitoring obligations in this. And so that was the reason for that, Representative, was for that initial period to try to get our arms around what we were dealing with here and not making it too onerous on law enforcement and DHEC.
Okay, any other questions, comments? Mr. Hill?
Thank you, Mr. Chairman, and thank you, Senator Davis, for your long and hard work on this and for sitting here with us today and listening to all the testimony. One of the earlier speakers brought up a question about constitutionality related to the sales tax, that provision, component of the bill. Can you speak to that? I understand there was some discussion of that on the Senate floor. For the benefit of our committee, could you bring us up to speed on what were the nature of those concerns and how were they addressed?
Right. The constitutional provision, and I think Ms. McGarry referenced it as well, says that revenue-raising bills must originate in the House. And if you look at the Supreme Court decisions interpreting that, as well as the AG opinions, because they've been asked about this, if a bill's primary purpose is revenue-raising, then that falls within the constitutional restriction. If revenue-raising is incidental or facilitating to an overall objective that's different, then that is not a revenue-raising bill. And so when I talked about this with Senate staff and Senate counsel, they said this isn't even close. This bill is about legalizing medical cannabis, and you've come up with a mechanism whereby you're going to fund the administrative costs in implementing that program. It's clearly incidental to the main purpose of the bill. The main purpose of the bill is to create a medical cannabis program. You've got a revenue component to it, not to raise revenue for the general fund, but to ameliorate the expenses that are associated with administering the program. So, and that issue was discussed and ultimately not raised on the Senate floor because those that were raising it became convinced that it wasn't a problem. I think, and there's many other instances where Senate bills have some sort of revenue-raising component to it, whether it's in regard to authorizing agencies to impose fees or develop fee schedules. But again, the South Carolina Supreme Court cases and the AG opinion that was issued just like 3 or 4 years ago makes it clear that if the main purpose of the bill is a public policy and you've got revenue-raising that's incidental to that, that is not a revenue-raising bill within the constraints of the state constitution.
Are we anticipating that there would be excess funds from this?
The way that I went about designing this was to keep those funds or the fees down as much as possible. Because, as was noted earlier, a lot of these medications aren't going to be covered by somebody's insurance policy. It's not covered by Medicaid. So you're talking about something that's going to be out of people's pockets. So I never viewed this bill as a net revenue raiser for the general fund. I tried to design it to where, and you'll see there are instances in the bill where it says the intent is to impose monetary components to ameliorate the cost of administrating the program. So I don't anticipate there being any excess monies. It wasn't designed that way. That could change depending upon use, depending upon how many people are authorized to take medical cannabis, how prevalent that becomes. I think we'll be in a better position to judge. And I would point this out because it hadn't been mentioned, but it was an important thing to a lot of people in the Senate. There's an automatic sunset in this bill so that it goes away by a date certain in the future. And I struggle with that because on the one hand, having a sunset like that might chill capital investment. If you're an entrepreneur coming into this space and investing capital, and if you see an automatic sunset in 6 or 7 years, that might cause them to hesitate to expend the money. But what I found was that these guys, these entrepreneurs, are used to operating in ambiguous space already, with it being a Schedule I drug under the CSA. And it was important to a lot of upstate senators in particular to put the burden upon the proponents of the program to have it reauthorized, because as we all know, it's easier to play defense in the General Assembly than offense. And that if it is a good program, and if it is accomplishing the things that the proponents are saying it's going to accomplish, then it ought to be on us to demonstrate that and have it reauthorized and not on the other side. So that's why that's in there. It's to guard against unintended consequences, and if there are unintended consequences, it sunsets without having to do the heavy lifting of getting a repeal.
And I appreciate that, Senator Davis. One final thing here is I keep hearing from detractors of the bill that there needs to be a meeting of the minds, that there needs to be more restrictions, that there needs to be more guardrails, that there needs to be some undefined standard that to be met that hasn't been met before we move forward with this. And I know that this has been a long process for you. Can you describe for those listening the process that you've been through over the last 8+ years in bringing stakeholders to the table? What kinds of testimony have you taken? What kinds of objections have you sought to address? And anything else that you think that we should be bearing in mind as we move forward and get ready to vote on this bill?
I think the first thing I would say is the number of qualifying conditions in this bill is a lot narrower than you're going to see in any other state. For instance, Mississippi that just enacted it, or was it Alabama? I got the two reversed. I think it's Mississippi. It has over 20 qualifying conditions, 22, I think. We've got 12. And the reason for that is early on, I sat down with the South Carolina Medical Association, who does not, I want to imply they support this bill because they've come out in opposition to this bill, as you probably know. But one of the things that they asked was limit the qualifying conditions to those for which there's overwhelming empirical evidence that cannabis can be a medicinal benefit. And so that's what we did. I mean, so every condition you see on there is overwhelming empirical evidence that cannabis can be medically efficacious in ways that pharmaceuticals cannot. So I would think that's the first compromise we made. The second was also in regard to—
And if I could interject real quick, I think
Yeah.
on one or two of those, you've added, as this has gone through the process in the Senate, you've added some additional constraints on some of those conditions, such as PTSD, some basic evidentiary things that have to be met.
In regard to the conditions, the two that were seen as being the most, quote, subjective were chronic pain and PTSD. And so we dug in and we tried to figure out a way, okay, how do we bring objectivity to what is essentially, in some sense, a subjective indication? And what we ended up with, and it's controversial, but we ended up with PTSD, that before a physician could authorize the use of cannabis by somebody who had been diagnosed with PTSD, there has to have been authentication and documentation of an underlying traumatic incident, okay? And we tried to phrase it in such a way that you wouldn't force the individual to relive it. Somebody who's a victim of sexual assault or somebody who's been in military in harm's way. But we did add a component that there has to be an underlying traumatic incident that's put forward that's verifiable. That was an effort to bring a quote, subjective thing, and I don't mean subjective in the sense that it's not real. I mean subjective in the sense that it's harder to diagnose and pinpoint than some other of the qualifying conditions. The second was in regard to chronic pain. And in that regard, what a doctor has to do is diagnose the etymology of that pain. In other words, not just an indication or a belief that the patient has pain, but diagnosing what the underlying cause of that pain is. And so those were two efforts to take the more subjective in terms of evidentiary components and to make them more objective. The second thing I would say we did in regard to the patient-doctor relationship itself. We didn't want to have pill mills. We didn't want to have, drive-throughs or somebody could drive by and just a doctor check the box and you go get your marijuana. We were very, very specific, very, very detailed in regard to the protocols and the steps the physician has to follow. And I would invite the committee's attention to that because a lot of time went into that to make sure that this wasn't going to be a sham. It was a bona fide bona fide in-person doctor-patient relationship that requires the physician to do a whole lot of things. the substance abuse history of the patient, for instance, because as been indicated, and it was testified earlier by the woman who talked about his son who ended up dying of a heroin overdose, that individual had anxiety, as I understood it, or depression, or maybe a tendency toward paranoia or things of that nature. You would not authorize the use of cannabis by somebody who is exhibiting those things. I mean, because marijuana can be dangerous. I mean, marijuana is not a panacea. Marijuana is not for everybody. And you may have a history of either drug abuse or indication toward or addictive behavior, or you may have that anxiety problem, and marijuana may be the absolutely worst thing in the world that you could be taking. But this inpatient diagnosis by the physician requires all those steps to be followed through. What's the patient's drug history? What's been their psychiatric history? It's very, very detailed. Physicians have to get continuing medical education in regard to becoming authorized to authorize the medical cannabis. I mean, again, I don't begrudge this. I want this to be a conservative bill. I want it to be a very careful bill that's well thought out. But that's another example of what we did. Law enforcement, I said, what's the number one thing you really hate about this bill? I know you hate a lot of things about this bill, but what's the number one thing you hate? We don't like the fact that we can see somebody, burning flower or smoking a joint, because to us, that's indistinguishable from the way marijuana is consumed recreationally. And when we're out there, we want to be able to distinguish between those who are consuming marijuana recreationally, illegally, and those that are accessing it medicinally, legally. And so we took out the burning of flower. Even though that's the most effective way of getting the cannabinoids in your system and provides the most immediate relief, we took that out because law enforcement was concerned about that. And it might make law enforcement's job harder. I did not want that. I've got tremendous respect for law enforcement. So we took that out. I mean, a lot of people weren't happy with me about that. A lot of people aren't happy with this bill at all. They feel they ought to be out there, be able to grow their own. I mean, why in the world is government interfering with their ability to grow a plant and take? And look, I mean, I recognize the libertarian in me recognizes the logic of that argument, but the politician in me recognizes that we're in South Carolina. South Carolina is a socially conservative state, and politics is the art of the possible. And I want to get relief and medicine in the hands of people who need it, subject to a physician's supervision. This was a way to do that.
And just piggybacking on to that, and I promise I'll be done here. We've heard it brought up several times, the issue of vaping. That vaping would be allowed, that the amount allowed to be in possession for inhaling via in a vapor form, some are saying is too high. There seems to be some concerns on that. Is this something that came up in the Senate discussion? How would you respond to those concerns?
Yeah, and I promise Ms. McGarry, I'm going to get this information as well, as to most state laws allow the burning of flower, okay? So what we had to do, once we said, okay, it's just going to be oils, okay? We're not going to have, it's going to either be vaping or tinctures or taking something orally or a salve. There had to be a way to translate volume of flower cannabis into oil. What's the conversion ratios there? And I don't have all that information with me, but I'm going to get that for you so that the committee can understand how we came up with the milligrams that are allowed for vaping, how we came up with the milligrams for tinctures, what are the milligrams allowed for oral consumption, what are the milligrams allowed for topical application. So I owe you that information. I need to get that to you. The last thing I want to do, and this is some really good work done by my friend Ms. Hudson, is in protecting children and wanting to make sure that something didn't look like candy or something didn't taste like candy or something that wasn't going to be accessed by kids who may be getting into the parents' medicine chest or something like that. And so she helped me, to her credit, as well did others, in coming up with language that doesn't allow the consumable to be in a form that appeals to children, that is of a flavor or a taste that appeals to children. It can't be marketed in that way with reference to things that appeal to children. I mean, we've gone about in every way we could to treat this like medicine, to make it look like medicine, so that it isn't, because I get it, I understand where she's coming from. You see some of these ads, you go to Colorado or whatever, and you can see it is like walking into, Willy Wonka's chocolate factory. I mean, you got all these sorts of products. products. That isn't what South Carolina wants, and she made a great contribution to the bill in that regard.
Any other questions, comments? Okay, hearing none. Thank you, Senator
Mr. Chairman, I
Davis.
stand ready to assist in any way that you would like me to assist. Mary Dennis has very ably represented you, but if I can answer questions about any of the Senate amendments or bills, please let me know, and I'm at your call.
Thank you so much.
Thank you.
Look,